everyone and welcome to a fresh episode of Legal Wrangle on corporate laws. Today we have 6 interesting cases ranging from the high voltage legal battle between Ericsson, Micromax and Intex in a competition law matter, scope of DRT in recovery suits filed by banks acting as debenture trustees, to a capital market matter where debt stocks have been traded fraudulently to make illegal profits. Towards the end, we take up the case of companies running radio cabs being dragged to the Competition Commission for indulging in alleged predatory pricing practices. Let us start with the latest judgment of Delhi High Court relating to the alleged anti-competitive practices by Ericsson regarding use of its standard essential patents by companies like Micromax and Intex. Manit brings the facts.
Ericsson, the petitioner, holds several standard essential patents or SEPs. When the respondents, that is Micromax and Intex, approached them for grant of license of these SEPs with respect to GSM technology, the parties could not arrive at an agreement over the royalty and ended up locking their horns. In 2013, Ericsson filed an infringement suit against Micromax and Intex on the ground that products manufactured and dealt with by the respondents violated its patents. On the other hand, in the same year, Micromax and Intex approached Competition Commission and obtained order for DG investigation against Ericsson for alleged abuse of its dominant position in creating an abusive royalty structure which is in violation of fair and reasonable and non-discriminatory terms, that is FRAND. Ericsson filed a writ petition before the Delhi High Court challenging the jurisdiction to commission to order DG investigation on the ground that issue related to royalty can be decided only under the Patents Act by the Controller of Patents.
The High Court quashed the petition in its 161 pages judgment and held that there is no inconsistency between Competition Act and Patent Act, and the issue of abuse of dominant position with respect of grant of license of SEPs on reasonable terms comes within the jurisdiction of CCI. Further, the court held that parties defending an infringement suit in a civil court is not precluded from approaching the Commission with respect of abuse of dominance by such patent holder. Dismissal of this petition means DG investigation shall be concluded into the affairs of Ericsson. In this ICICI Bank case, the Bombay High Court had to step in to settle the issue of jurisdictional conflict between debt recovery tribunals and civil court. The main issue is whether a bank appointed as debenture trustee by the borrower can file a civil suit, or is it only the exclusive jurisdiction of DRT to adjudicate such matters. Here are the facts.
The appellant ICICI Bank Limited was appointed as a trustee for the debentures issued by the borrower company. When ICICI sued the borrower as a debenture trustee for the recovery of the amounts payable, the borrower raised objection on the issue of jurisdiction of this court to entertain the suit and argued that only the DRT has jurisdiction to entertain the said suit. The division bench of the Bombay High Court ruled in favor of the borrowers. Finally, the appeal was heard by the larger bench.
It was held that as per Section 17 of Recovery of Debt Act 1993, jurisdiction of civil court is barred only when the lending bank or financial institution sue the borrower for recovery of loans to itself. However, in this case, ICICI Bank was acting on behalf of the debenture trustee and hence they were not suing for themselves. Hence, suit is maintainable before the civil court. Our third case is about the rights of a secured creditors in the backdrop of interrelationship between the Companies Act 1956 and the SARFAESI Act. The bone of contention was whether the company court directly or through an official liquidator can avail any control in respect of sale of secured assets by a secured creditor in exercise of powers available to such creditor under the SARFAESI Act. Here are the facts.
The appellant, Pegasus Assets Reconstruction Private Limited, was sole secured creditor of the Haryana Concast Limited, which was undergoing liquidation process. The appellant informed the official liquidator that it intended to remain outside the winding up process to enforce its security as per the provision of SARFAESI Act. The company judge allowed the same but put certain restrictions on its powers. The matter went to the Supreme Court.
The Apex Court once again upheld the powers of secured creditors under the SARFAESI Act, which cannot be curtailed or interfered with the company judge. The court also said that SARFAESI Act is a complete wholesome act to deal with secured creditors till the stage the secured assets are sold. Well, another case of capital market fraud and unfair trade practices to earn profit out of illiquid scripts. Yes, our fourth case deals with the question whether fraudulent exercise with prior meeting of minds can be inferred from circumstantial evidences which indicate brokers trading in a suspicious and coordinated pattern. Maneet has the facts.
Some sub-brokers were alleged to have synchronized trades in respect of a huge number of shares during the periods in question of illiquid scrip. Quite interestingly, all the buy and sell orders were placed within a time gap of 0 to 60 seconds between the same set of brokers, and that too without settlement of accounts. The SEBI treated this as a violation of sub-brokers' regulation and imposed penalty on them.
On appeal, the Supreme Court agreed with the findings of the SEBI and held there was sufficient circumstantial evidences which show prior meeting of minds between the sub-brokers to artificially jack up the prices of the dead stocks. In this case, the Director General of Health Services landed up in trouble when allegations were made against it for indulging in anti-competitive practices. The question was whether functions of DGHS can be treated as sovereign and whether they come within the scope of enterprise under the Competition Act. Let's find out the details.
The informant, a retired wing commander, accused DGHS of discrimination between hospitals on the basis of their accreditation and for arbitrarily hiking the hospital base rate. As per the appellant, DGHS was indulging in unfair trade practices by abusing its dominant position. The Commission held that since DGHS has not directly engaged in any economic and commercial activities, it did not qualify as an enterprise under Section 2H of the Competition Act.
The tribunal held that Commission made a mistake in understanding the scope of enterprises. It held that DGHS provides preventive as well as curative healthcare to central government employees, retired central government personnel and their dependents, and therefore they do not perform any sovereign functions. In other words, they qualify as enterprise and therefore not immune from investigation under the Competition Act. Our last case would definitely bring smile on those people who love travelling in Ola cabs. Yes, this is again a competition law case dealing with the issue of alleged abuse of dominant position and anti-competitive practices by Ola cabs running radio taxi cabs in Delhi NCR region. The key issue was whether offering of rebates, discount, free rides, etc. amount to predatory pricing or abuse of dominant position, resulting in eliminating competition from the market. Maneet has the details of the case.
Mega Cabs Private Limited filed information against ANI Technologies Private Limited, which runs radio taxi cabs under the popular brand Ola. The informant accused Ola for indulging in abusive tactics like predatory pricing, offering periodical rebates, discounts, free rides and reduction in the minimum fare and so on, with the sole aim to eliminate competition from the market.
The Commission concluded that Ola was not in a dominant position in the radio taxi service market in Delhi region because the reports indicate that the market share in the relevant market keeps fluctuating, which is an indicator of competition in the market. A similar decision was also given by the Commission in the case of Uber radio cabs. In that case, the Commission even held that it is not a competition concern if the company receives funding from venture capital, which in turn used in technology and better marketing strategies to attract customers. In nutshell, the customers will continue enjoying the attractive discounts and offers. Well, this brings us to the end of this episode of Legal Wrangle on Corporate Laws. Thank you for watching.